Order. I call the member for Melton.
Thank you, Mr Speaker. I rise today to speak in support of the Guardianship and Administration Bill 2018. This is a very important piece of legislation. The purpose of the bill is to replace the current Guardianship and Administration Act, which is over 30 years old and is underpinned by outdated policy, with a legislative framework that is based on a more contemporary understanding of decision-making capacity and disability. During my career as a paramedic, I witnessed people with dementia, acquired brain injury and mental health disability not being included in decisions that had an effect on their lives. I'm pleased to say that we have made considerable progress since those days. This bill is another example of the progressive nature of the Andrews Labor government and the support for affected Victorians covered by this bill. In summary, the bill recognises the need to support people with disability to make, participate in and implement decisions that affect their lives. It sets out what is meant by decision-making capacity, which includes being able to make decisions with support, and provides that decision-making capacity must be presumed unless there is evidence to the contrary. It provides further statutory recognition for supported decision-making, including through the appointment of a supportive guardian or a supportive administrator to support a person with a disability to make their own decisions. It enables VCAT to make appointments of guardians and administrators. It improves processes at VCAT when dealing with guardianship and administration applications, including by ensuring greater participation of the person with the disability and inclusion of those in important relationships with that person, such as family members and carers. It provides guidance for guardians and administrators when making decisions for represented persons, so that the will and preferences of the represented person direct the decision-making as far as possible. It also allows VCAT and the Supreme Court to order compensation for a lost cause by a guardian or administrator contravening the legislation. It includes offences to penalise guardians or administrators who dishonestly use their appointments to gain a financial advantage. And it allows for enforcement through VCAT of decisions of guardians and administrators against third parties. And finally, it makes amendments to improve the operation of the Office of the Public Advocate. The question may be asked as to why we need to reform the laws, Acting Speaker. Public policy concerning people with disability in the 30 years since the enactment of the Guardianship and Administration Act 1986 has changed. In particular, the emphasis has moved from protecting people with disability in a paternalistic sense to recognising their individual rights and facilitating their participation in community life. Central to this has been the development of the United Nations Convention on the Rights of Persons with Disabilities, which Australia ratified in 2008. While historically the Guardianship and Administration Act was a response to the deinstitutionalisation of people with an intellectual disability, it is now used by people with varying impaired decision-making capacity due to a range of disabilities. The Victorian Law Reform Commission's Guardianship report was tabled in Parliament in April 2012 and recommended a range of reforms to respond to changes to the social environment in which the laws operate and the range of people who use the laws. It is anticipated that the major user groups of guardianship laws over the next 20 to 30 years will be people with an age-related disability, an acquired brain injury or a mental illness. Ageing is the main factor affecting the incidence of disability in the community, with dementia being the leading cause of disability in people aged over 65. In fact, Access Economics has projected that the number of Victorians with dementia is likely to increase from the present figure of approximately 65,000 to 141,000 in 2030 and more than 246,000 by 2050. Importantly, the Guardianship report recognised that a person with an age-related disability such as dementia is likely to experience a gradual loss of decision-making capacity over time. The decision-making capacity of a person with an acquired brain injury might return over time, while for a person with a mental illness, it is likely to fluctuate as their condition fluctuates. The bill responds to these factors identified in the Guardianship report by providing mechanisms for the supported decision-making, requiring VCAT to make guardianship and administration orders that are tailored to a person's individual circumstances, requiring a guardian or an administrator to give effect to a person's will and preferences as far as possible, but allowing will and preferences to be overridden to avoid serious harm. The key reforms in the bill are a new definition of decision-making capacity. The current Guardianship and Administration Act does not define decision-making capacity, which is a key concept in the operation of guardianship and administration laws. The bill also includes principles that reflect a more contemporary understanding of decision-making capacity and disability, so as to enable VCAT to set limits on appointments and to provide guidance to guardians and administrators. The bill provides that the person and social wellbeing of a person are prompted by recognising the inherent dignity of a person, respecting the person's individuality, having regard to the person's existing supporting relationships, religion, values, cultural and linguistic environment, and also respecting the confidentiality of all confidential information relating to that person. It allows VCAT to make guardianship and administration orders for an adult with disability, but ensures that the order is proportional and tailored to the person's circumstances. It clarifies the basis for the order. The person, because of the disability, does not have decision-making capacity in relation to a specific personal matter or a financial matter. The person is in need of a guardian or administrator, and the order will promote the person's personal and social well-being.
The member, I'll call on the member for Kew.
Draw your attention to the state of the House.
Quorum is not present. Ring the bells. Quorum is present. I call on the member for Melton to continue.
Thank you, Acting Speaker. Some may ask, Acting Speaker, why introduce a new appointment of a supportive guardian or supportive administrator? As a less restrictive alternative to substitute decision-making, the bill promotes supportive decision-making, including through an appointment of a supportive guardian or a supportive administrator. Under the definition of decision-making capacity in the bill, it is recognised that a person has decision-making capacity for a matter if it is possible for the person to make a decision in a matter which is practicable and appropriate support. The appointment allows VCAT to appoint someone in a more limited role than a guardian or administrator, but one which supports a person with impaired decision-making capacity to make and give effect to some or all of their own decisions. Support in decision-making often comes from family members and trusted carers. The appointment of a supportive guardian or supportive administrator acknowledges these relationships while ensuring that a person with disability retains their right to make decisions. The bill ensures that the existing orders of VCAT remain in effect and that, in broad terms, existing guardians and administrators are not subject to new duties or obligations without this first being the subject of VCAT consideration and determination. On commencement of the new Act, and despite the repeal of the old Act will continue to apply to guardianship orders and administration orders, including administration orders for a missing person made under the old Act and that are still in force. The old Act will continue to apply until those orders are reassessed, whether at VCAT's initiative or on application, or in the case of a missing person, the order expires or is revoked. New orders will then be made under the new Act. However, the following new processes under the new Act will also apply to existing orders. The dispute resolution process for guardian administrators for the same represented person, the ability to seek enforcement orders against third parties, and the compensation provisions and the offence provisions. Acting Speaker, people living with impaired decision-making ability deserve the dignity and independence of being supported to make their own decisions. It is for these reasons that I offer my support for this bill, and I look forward to a smooth passage of the bill. Thank you.